Course: Alternative Dispute Resolution, ADR. Topic: Lesson 3. Mediation, also called conciliation or facilitation. What is mediation, conciliation, facilitation? Mediation, also called conciliation or facilitation, is a process of peaceful dispute resolution in which the disputing parties present and consider proposals until one is formed and accepted. Mediation in Cambodian context. Mediation, conciliation, is a practice rooted in Cambodian custom. Cambodian society has long relied on respected elders and community leaders to help resolve conflicts. For example, village-level disputes. In small disputes, the neutral helper, mediator, conciliator, facilitator, can be respected elders, parents, or friends. Officials in relevant institutions, such as commune or sangkat offices, and district provincial administrations. For labor disputes, labor inspectorate or Ministry of Labor officials. For commercial disputes, Chamber of Commerce or Ministry of Commerce officials. For land disputes, cadastral commissions, administrative authorities for land conflict resolution, or the Ministry of Land Management, Urban Planning, Construction. In certain matters, parties may first attempt mediation for up to 15 days at the commune or sangkat level before a case is forwarded to the courts. In interpersonal or family conflicts, example, disagreements within kinship or neighbors, respected community figures such as village chiefs, monks, teachers, or elders may be invited, depending on the influence they hold over the parties, to facilitate dialogue. Comparing mediation and negotiation. Generally, mediation and negotiation share core features. They aim to de-escalate conflict and rest on voluntary participation to reach agreement. Key differences include mediation. Third party, the mediator, facilitates communication. Process can be more structured: intake, ground rules, agenda, timelines, fees. Focuses on interests and relationship repair. Confidential caucuses possible, private sessions. Flexible procedures and documentation. Negotiation. Parties talk directly without a third party. Process is informal and set by the parties. May focus more on positions. No neutral to manage dynamics. When mediation is suitable. When parties want to maintain or rebuild an ongoing relationship. When parties share a desire for a rapid, private resolution and mutual trust exists. If trust is low, suspicion may push parties to seek a neutral third party, mediator, conciliator, or facilitator, who may be an official or trained professional. When parties want clarity about the procedure and their roles in the resolution process, mediation provides a transparent framework the parties can understand and follow. Core values and principles of mediation. Strengths: voluntary participation, process or settlement. Confidentiality, example per UNCITRAL style standards. Flexibility in process and outcome. Speed and efficiency, often event-based and short in duration. Party self-determination, outcomes crafted by the parties. Relationship preserving, useful in business and community. Cost-effective and accessible. Additional advantages: high chance of settlement compared with positional bargaining. Parties feel heard, can vent and be acknowledged. Avoids coercive power. The mediator has no adjudicative authority. Parties choose the mediator based on expertise, integrity, availability, and rapport. Limitations: no enforceable power by the mediator. Imbalance of power can carry into mediation. Complex or technical cases may require expert neutrals or specialists. Voluntary nature means no guaranteed settlement. One party may be much stronger, affecting dynamics. The 7 stages of a mediation. Initiating mediation. Mediation may begin under various circumstances. Commonly, a party sends a letter of invitation proposing mediation, indicating venue and proposed rules. If the other party agrees, parties settle the ground rules and select a mediator. If the other party declines or stays silent, mediation does not proceed. Some frameworks treat no reply within 30 days of notice as a refusal. Courts or administrative bodies can also encourage or refer cases to mediation and help set rules and appoint mediators. Selecting the mediator. One or multiple mediators may be chosen. Selection can be from mediator rosters or lists. A well-known center, example, a national or community mediation center, or based on expertise, integrity, availability, and rapport. Providing information to the mediator. Each party provides a brief of facts and issues and desired outcomes. The mediator seeks clarity. In multi-party matters, parties may submit written statements, facts, evidence, claims or defenses, and positions, along with supporting documents, so the mediator understands the dispute landscape. Opening joint session. First, ground rules. After reviewing submissions and logistics, date, time, and place, the mediator convenes a joint meeting. Who attends? The mediator, both parties, and, if needed, counsel or representatives with clear authority to settle. Purpose: clarify goals, reduce suspicion, and establish a cooperative tone. The mediator explains the process, participation, turn-taking, confidentiality, respectful communication, etc., and confirms that information shared is for problem-solving. Problem-solving and option generation. The mediator surfaces issues, clarifies misunderstandings, and explores interests and impacts. Tools include reframing, summarizing, testing assumptions, identifying objective criteria, and brainstorming settlement options. The mediator may outline BATNA and WATNA considerations, best, worst alternatives, to help reality test proposals and highlight the risks of impasse or litigation. Private caucuses, confidential meetings. Where appropriate, to avoid deadlock or manage sensitive information, the mediator meets each side privately. Parties may disclose confidential interests, constraints, or proposals they are not ready to share in joint session. Example, cash flow limits, internal politics, reputational concerns. Private caucus is useful when both parties consent. The case is highly contentious. Power imbalance is acute. Emotions or threats have escalated. Closure, adjournment, or termination. A mediation ends when the parties reach a full settlement or the parties partially settle and agree to continue or to formalize unresolved issues, or no agreement is reached and the mediator closes the process. The mediator should summarize key points, confirm commitments, and, where there is agreement, assist the parties or their counsel in drafting a settlement agreement. The mediator may also recommend next steps to reduce future conflict. Communication skills used in mediation. Active listening and respectful tone. Reframing, redefining how a problem is seen to open constructive discussion and move from positions to interests. De-escalation, lowering tensions so parties can think clearly and collaborate. Generating options, encouraging creativity before evaluating solutions. Reframing helps to reduce hostility and defensiveness, shift from positions to interests, convert complaints into solvable issues, breaking impasses, separate people from problems, reduce personal blame, focus on interests, not positions, invent options for mutual gain, use objective criteria to evaluate proposals. Concluding note: mediation is an effective, relationship-preserving method of dispute resolution.
However, success depends on the parties themselves. Even when mediation ends without agreement, parties retain other avenues: private negotiation, administrative settlement mechanisms, or ultimately the courts. Mediation encourages understanding, reduces costs and delays, and often produces mutually beneficial, durable outcomes.